Thank you everyone for coming. This is a workshop on temporary faculty employment, and I'm Randy Erickson, and I'm an attorney and the owner of Erickson Law Firm. I've been representing the district here for a long time, I'd say at least 7 or 8 years. The topic we're going to talk about today is temporary employment. It's going to involve the 67% rule and when you can use it, when you can't, and other things. The overview of the training presentation we're doing, we're going to talk about adjunct faculty and the 67% rule, and that's one category. Then you've got short and long-term substitutes, and then categorically funded employees. And each of these are types of temporary employees, but they've got separate requirements and separate obligations and entitlements that go along with those. And they get mixed up a lot. This has kind of become a big issue, not only at this district, but at several other districts that I represent. It becomes an issue because there's confusion as to what's required to put somebody in a full-time temporary position versus when can you mix it with your 67% and your full-time substitutes. The consequences are pretty serious because you can end up owning faculty members if you don't classify them correctly or if you don't follow these rules. So the authority that governs what we're talking about, you've got your education code, you've got Title V of the California Code of Regulations, you've got your collective bargaining agreements with mainly with the CODFA and CODA. CSEA is this. I'm doing 2 presentations, and this was all one, and so that's why CSEA is on there. They don't really have anything to do with this one. You've got your agreements, you've got your board policies, and then the EERA govern to a certain extent as well.
Randy, just have a second. So of the individuals here that work with 67%, do you sometimes wonder how to count what 67% is, or what to do with it, or what not to do? Yes. Yeah, you're pretty good. Do you track it in your departments? No. Yes. So that's what I was curious. I was asking the HR staff who's tracking the 67%. Because I've been accustomed to, it was somewhat of a relationship between the student learning area and HR, and when we get a PAF form, there'd be one person there who counts and makes sure the person isn't over 67%. But I haven't had a really clear answer on who's really checking it to be sure we backstop what the deans send forward. So I hope we can figure that out.
In the past, it was Stephanie's position. The person before Stephanie used to keep a running tab and then send it out to us every semester so that we knew what the history was.
Okay.
So we didn't keep it in our own areas, but we were sent that information from Tom Jones, who was Stephanie's position.
So if the person is working in 2 different schools,
yes,
would you still have that information on that document?
but that's why the schools can't really do it, because we don't always know what's happening in the other schools.
So you take care of it for what you know, but you don't have access to see that that person is teaching in English as well as
Yes.
physical education.
So one of the things I'm curious about is why we're not tracking this on the person's screen with the employee identification number inside DataTel, and that we should program that process so that there's a red flag that comes up when somebody slowly hits X. Mm-hmm. And so we don't have somebody from IT with us today in this meeting, but one of the things that we can do with DataTel is set it up that way. We also probably want to have greater training on DataTel for the entry point, so we don't have one single individual doing that piece. This should be the place where we're doing the error reporting, where we're doing the fact checking, where we're doing the final step. But I think deans and deans assistants should probably be greater empowered and greater trained for the input so that they can see when something like this is coming before. The way Stephanie's job is typically managed, it's at the end, it's a place that happens right before payroll, which is not our best place to be stopping the problem, right? We want it when we're loading and assigning, so we want it to occur earlier. That's one of my goals. Right?
That's helpful. I just need to see the context of that's not uncommon from where you've had these discussions.
No, that's not uncommon at all. A couple of preliminary considerations. As we're getting into this, the reason we're having this training is because large parts of the education code are not meant to be understood. These are actually quotes from appellate court cases, and so you have a trial and you have a judge makes a ruling. Those judges then appeal it to the next level. So they're the highest levels of appellate court judges who are interpreting the law that we're all trying to operate under, and they don't understand parts of the education code. So it's not easy stuff. We decline the invitation to complexify further the education code, and entry into the education code is painful. That particular case, you'll see it's Haas versus San Diego Community College District. That was how one of the justices introduced a case that dealt with a temporary employee who was hired as a categorically funded employee, then went back to a temporary employee, and then they wanted to become permanent employee because of that time in there. So it's something that related to what we're talking about today, and that's where he came up with, that's the opening part of his decision, is entry into the education code is painful. And then of course the academics or politics are so vicious because the stakes are so small. The other thing to keep in mind, and here's where a lot of the confusion comes up when we're dealing with temporary employees. Temporary employee categories are kind of like cars, and they all have four wheels and doors and they move down the road, but you can't take Ford parts and put them in a Chevrolet. You can't take Mercedes parts and put them in a BMW. You have to use the parts that fit with the temporary employee status that you're using. And so one of the things that we come up with frequently is things like, well, I can exceed 67% 2 semesters out of 3 and I'm good, right? They're completely different temporary category assignments. There is a type of temporary employee that you can hire for 2 semesters out of 3 full time, but it's not 67%. Okay, so when we're going through these, what we're going to try to do is talk about each one individually and then what each of the requirements are for that type of employee. So, the 3 types of faculty members. In general, the broad picture, you've got your contract or your tenure track. Those are your probationary employees. They're hired on a contract. They serve the first 4 years as probationary, but they work full time. You've got your regular employees who are your tenured permanent faculty members. They work full time. And then you've got temporary. And the distinction and the reason why it's important is because temporary faculty have far fewer rights than contract faculty and regular faculty. They can be dismissed, temporary faculty can be dismissed at the end of a day, at the end of the week, and it's at the discretion of the board. Full-time faculty and contract faculty, you have to go through your discipline process if you're going to let them go. Whether it's through the non-renewal, if they're probationary, you still have to do that if it's effective at the end of the year. If you're going to do it any time other than the end of the year, you have to go through your 90-day notice if it's unprofessional conduct or unsatisfactory performance. If it's any of the other grounds, dishonesty, membership in the Communist Party, whatever, then you've got to go through your hearing process, and it's a long, drawn-out due process. And the reason is because the legislature has given employees, faculty employees, full-time and classified employees, a property right in their position. They own property, so in order to take away that property under the U.S. Constitution and the state constitutions, you have to go through due process and give them a hearing and a right to be heard and evidence presented, and it's a complex thing. You don't have that with temporary faculty because they don't have a property right to their position. They're also not automatically rehired each academic year. Now, rehire rights are considered a mandatory subject of bargaining, and in your contract, returning adjunct faculty members under the adjunct's collective bargaining agreement only requires written notice of 30 days before the end of the beginning of the semester. You need to notify them if they're not going to start 30 days before, right? If any of you are on the negotiation team, don't give them more than that, right? keep your rights the way they are. Adjunct faculty members typically have a lower salary schedule. They don't receive health care benefits. If they then become full-time because these procedures aren't followed, then it not only has an impact on your faculty members, you've basically brought somebody in without going through a recruiting process and going through the vetting and recruiting process, but it also has an economic factor because they weren't getting benefits before. Now they've got the right to benefits. They're subject to less frequent and less rigorous evaluations, and so it's critical for administrators to ensure that faculty members are correctly classified. And if you don't, then that's when you quote-unquote own the faculty members. And that's when they basically get a right to a contract position, or if they've been here long enough in violation, they may end up with a permanent position. So the types of temporary employment, temporary faculty we're going to talk about, and these are all separate ways you can be a temporary faculty member. You can be an adjunct faculty, which is under the 67% rule. You can be a day-to-day substitute. You can be hired to teach temporary classes. You can be hired in emergencies. You can be a full-time substitute for an existing employee who is absent from the district for a short period of time. You can be hired because you have a higher number of students that have come in than what was expected. So if you've got, if you have an influx of chemistry students and you need to hire somebody, if you can demonstrate that you've got this increase in the students, then you can hire full-time faculty on a temporary basis to support that. And you've got categorically funded employees. And each of these have different rules and requirements that need to be followed.
I'm familiar with all of these categories except for temporary classes. Could you?
Yeah, so if you just, we'll talk about this in more detail.
Okay.
But if you offer classes for 3 months during the first part of the year, or it's offering classes for a short period of time. It's not the full semester. They're offered for a short period of time. And a lot of times I think this comes up in like your police department or your police training classes and fire. They'll have 3-week classes or 4-week classes. At certain, I mean, at some districts they have, it's not the full semester long class. It's a short class time, temporary class. Part of this also is the reason that it also becomes important. You might think, well, they're part-time, they're doing real good, let's just let them go and become full-time. But the courts have recognized, and I think a lot of people have recognized, that just because somebody's a good short part-time employee does not mean that they'll be a successful full-time employee. It's one thing to show up and teach 1 or 2 classes. It's another thing to take on the responsibilities of your committees and teaching full-time classes and keeping a schedule and maintaining office hours and everything else. And so some people are very good at showing up. They've got their day job in the morning and they come teach classes at night or come teach classes when they can, but that doesn't necessarily mean that they're going to be a good full-time employee. So you want to make sure that you have vetted them properly through your hiring process rather than have them become a full-time employee this way. All right, so the first thing we'll talk about is the 67% rule, and that's found in Ed Code 87482.5. It used to be 60%, and 7 or 8 years ago they changed it to 67%. And what that says is that employees who work less than 67% of the hours per week considered a full-time assignment of a regular employee are considered temporary employees. And so there's a couple of things that go along with that. Service as a substitute on a day-to-day basis doesn't count towards the 67% rule. So when somebody comes in and says, hey, these are the classes I'm teaching, plus I'm teaching these substitute assignments don't count. Service in professional or ancillary activities such as governance, staff development, grant writing, those don't. Yes?
What about coaching? Does coaching count?
Coaching does not count.
Thank you.
Now, if the coach is teaching phys ed classes,
Yes.
right,
Yes.
that time counts. The class time counts.
Any credit-bearing class?
Credit bearing, not only credit bearing, but apportionment bearing. Credit and apportionment bearing, right? But if it's not, but coaching as far as the practices and going to the team events, that does not count towards, and there are cases that talk about that. In determining what is a full-time assignment, okay, and again, just go back. So you've got a part-time contract and you've got a full-time contract, right? The part-time contract can define how that employee is paid on a part-time basis, and then maybe they're going to pay them by the hours, maybe they're going to give load factors. Maybe they're gonna, maybe they give them credit for planning and grading and all sorts of. The standard is what's 67% of a full-time load. You don't look at how they get paid under their part-time contract. It's how you calculate the load for a full-time faculty member, and does that exceed 67%? And I've had situations where an employee is paid as an adjunct for different duties that they look at it and they say, well, when I calculated under the adjunct contract, I'm up at 75%. It's like, okay, that's how you got paid. But for purposes of 67% rule, we look at the full-time faculty contract, and we calculate your load under that formula. And that's what determines whether or not you're above the 67%. The courts have held that the district has considerable discretion in determining what's considered a full-time assignment. And part of that discretion then comes in how you negotiate with your full-time primarily. For teaching faculty at COD, the COD faculty agreement, and both of them define the full-time assignment as 30 semester instruction units per year. Okay, so there's some important things with that. The full-time faculty define them as 30 semester instructional units. So anything that doesn't count as an SIU doesn't count towards load, right? The other thing is, this is a relatively recent change. I think this came into effect in the spring semester of 16. Prior to that, it was 15 SIUs per semester. The problem that could come up is when you limit it to 15 SIUs per semester, then you can't balance it between the year for your adjuncts. And I think there was a past practice that they've done that for several years, but this makes it clear that this is averaged over the course of the year. So if you can be at 70% one semester and 50% the other, and as long as they balance out for the full year, then you're fine with the 67% rule. And then for the exception on the SIUs is for your librarians and counselors. I think we talked about this earlier, but the CBA defines librarians and counselors as having a 40-hour work week. So I may have been mistaken. We'll double check on that. So what you looked at then is you look at the SIUs for your instructional faculty, and then you look at what their work week is for librarians and counselors, and it's 67% of that amount for both teaching and non-teaching faculty. For your adjunct teaching faculty, then 60% of the full load will be 20 SIUs per year. And you can average that between semesters, but you can't roll that over to the next year, right? So the maximum of 67% a year can't be rolled into the future year. So you can't say, they can't say, well, I was at 70% in the spring semester, and I was at 70% in the fall semester of the next year, and if you look at that year, I'm over the 67%. It's within an academic year, right? So as long as you're less in one and more in the other, you're okay, but you don't carry them over, you don't do the calculation across academic years. And then for adjunct and librarians, 67% would be an average of 26.8 hours per week based on a 40-hour week. If it's less than that, then it'll be 67% of that. What does constitute a full-time assignment? It's assignments that are measured in SIU. So it's your lecture, your credit and non-credit, your lab credit and non-credit, any hybrid credit, non-credit courses, phys ed, labs, physical education, varsity sports. If it counts towards your SIUs, then it counts towards the load. Non-credit ESLs, right? Everybody's familiar with credit, non-credit, not for credit, right? Credit is you get credit and apportionment from the state. Non-credit is you don't get the credit, but you're getting apportionment from the state. And then not for credit is your contract ed, your community service, where the student doesn't get credit and the school doesn't get apportionment for those classes. Full-time assignments do not include your not for credit classes. Your, like I said, your community ed classes, your continuing education, contract ed work. It doesn't include office hours. It doesn't include committee work. It doesn't include coordinator positions. It doesn't include extra duty assignments. Just to clarify, I'm not talking about overload, right? Overload would count. So that's an extra duty assignment. But those are teaching assignments. But it doesn't count any other additional extra assignments that are given to faculty members, day-to-day substitutes. So if the reason you're on campus is because somebody else is gone from campus, then that time wouldn't count towards the 67% rule either.
Wait,
Yes,
what about a long-term substitute?
we'll get there.
All right.
We're getting close. As far as these coaching, the actual physical coaching, tutoring, sometimes you'll have tutoring sessions set up. Tutoring doesn't count. Those types, even though it's teaching related, it's not generating the SIUs. It's not counting. The other thing is an adjunct. The 67% rule is a separate way of being a temporary instructor. So if you have an adjunct instructor under 67%, you have a need for a full-time temporary instructor for one of the ways we'll talk about, whether it's because of a substitute or because of an increase in enrollment. They can come in and they can serve a full semester or up to a full year as their substitute and then go back to an adjunct position and you're fine, right? Where you get in trouble is when you've got them as a full-time substitute and then they're hired for that next year. That's when you'll get in trouble. But just because you use somebody as a full-time substitute doesn't mean you're prohibited from then using them as an adjunct later on. As long as they're less than 67%, you can use them. Now, you've got this averaging at the district where you can average it over the course of a semester. I would be real careful if you've got somebody who served as a full-time substitute and then the next semester you bring them in at 70 or 75% with the intent of bringing them down below after that, because I think they may have an argument, well, we're above again. Bring them in low the first semester and then you can raise them up the second semester and you'd be fine. Okay, and then it averages out. The problem is once you get into that third semester, they're up above and they may have an argument that they've been hired for the third semester out of two. Other full-time considerations are irrelevant. So this comes up frequently. They say, well, they're not generating the SIU, but look at the actual number of hours they're working. Well, it doesn't matter what hours they're actually working on grading papers or preparing for the class or anything. What matters is what generates the SIUs. The definition of full-time under the Labor Code or under the Affordable Care Act that's not what's determinative here, right? So the Affordable Care Act sets a certain threshold in order to get health care. Well, that defines what health care benefits come in, but that doesn't define whether or not somebody's working. That doesn't define what a full-time load is. Whether the hours worked include instructional duties, if you're teaching a contract ed class, you're teaching, but it's not generating the SIUs. It's not for credit, so you don't get to count that. And it also doesn't matter whether or not those hours count towards CalSTRS. Whether you get CalSTRS credit or not, that's not important in determining whether somebody meets the requirements for the 67% of a full-time faculty member's load. So some common misconceptions or common mistakes that we've seen with regard to 67%. One of them is that they count tasks outside of the load as counting towards 67% rule, so they'll count coaching duties. And a lot of times this comes from the misconception from the faculty side. They'll come in and they'll say, well, I spent all this time on committee work as an adjunct, but I didn't get credit towards my load. Or I spent time coaching. That one comes up pretty often. Or I'm teaching these contract ed classes, and I'm teaching, that should count towards it, okay? Again, it's just SIUs. The other one that comes up is there's this idea that employees can be assigned over 67% for a certain number of semesters, and it's mixing up two different areas, right? As a full-time substitute, you can work 2 out of 3 semesters as a full-time, and you're fine under certain conditions. But I've had administrators come and say, oh, I didn't work them, they didn't work more than 67% for more than 2 out of 3 semesters. You're putting Ford parts in a Chevy car. It's not the same not the same requirements. And the day-to-day substitute assignments count towards the 67% rule. That one comes up fairly frequently as well. It's confusing. The reason the multiple semesters is confusing is, and it's been probably 7 or 8 years now, but they used to be part of the same statute. It used to have the 67% in like subsection A, and then in subsection B they talked about the full-time faculty, full-time temporary, and people would get them confused all the time because they thought they matched together. So the legislature then separated those out into different sections to make it less confusing, but people already had this idea that they work together, those statutes work together. There was a case that talked about, that distinguished between them and said, no, this is one way, this is the other way. The other common mistake that's not done on here, and this is going to be a common theme throughout, but when you hire the employees, it's very important that whatever their initial hiring documents are, says what you intend them to be, right? So you want them to be, if you're hiring them as an adjunct, 67% or less instructor, you ought to have their hiring document indicate 67% or less if they're hired as an adjunct instructor. And you're going to see this as a common theme throughout here, because how you classify them initially is how a court or how a judge is going to look at those later and what you intended them to be. And so if you've got them hired as a contract employee, but you have them less than 67%, but the hiring documents, you just use the contract employee form, they're going to say, well, you must have meant to have them as a contract employee, right? And so they become a probationary employee, even though you meant for them to be less than 67%. It's how you classify them up front that is determinative, one of the determinations. All right, any questions on the 67% rule? Okay. Next one is your day-to-day substitutes. This is an entirely new category of temporary employees. A temporary employee can fill positions of regular employees who are absent from service or position. When somebody goes on leave, you can hire somebody in on a temporary basis to fill their job, right? The assignment has to begin after September 1st. If somebody notifies you, and I just had this come up at one of my colleges, they called up and said, hey, we just had somebody give notice effective August 1st. Can we hire a temporary substitute for the rest of the year? You can't, because the idea is if it comes up after September 1st, then you've got to fill a vacancy that you weren't anticipating. And recruiting and advertising and finding faculty aside, I know there's a burden with that, but the legislature says that if it happens before September 1st, then you either need to find a way to use adjuncts to fill those positions, or the person you hire is going to be hired in as a contract employee. Okay? If it's after September 1st, then you can hire somebody on a temporary basis to fill it, if there aren't any regular retired employees available. Okay? So that's sort of this aside that there has to be no regular retired employee available. If you hire a full-time substitute in there, you're going to need to be able to show that you made an effort to try to see if there's any full-time or regular retirees that could be available to come in and fill this position, right? So just be aware that you've got to go through that process. And yes.
Can you hire the person as an adjunct from August 15th through the end of the month, and then hire them as the temporary starting September 1? Does it have to be a different person?
No, I don't think it has to be a different person. So your question is, can you hire?
Because classes begin in August.
Right.
And you're going to hire an individual to fill this position.
Right.
So you wouldn't have someone teach a class for 3 weeks and then bring in somebody else who's the temp for the rest of the semester.
I see what you're
Can it
saying.
be the same person?
I think the assignment, the vacancy has to begin after September 1st. Right? So the person has to let you know, I'm not going to be able to continue. And that if it happens before September 1st, I don't think you could use adjuncts and then hire that person as a temporary substitute. I think they would say, no, that's getting a little too tricky. But I think what you could do is, if the vacancy occurs after September 1st, in other words, somebody comes in and says, I'm sick, I've got to go out, I'm taking another job, if it's before September 1st, you gotta either fill it with adjuncts, fill the duties all the way through the year with adjuncts, or hire somebody in as a contract employee.
If you did hire a retiree, is there a cap on the number of hours that they can work?
There might be for the employee as far as STRS rules go. They might have some restrictions on what they can do. Otherwise, they can come in as a full-time employee, but it depends on when they retired and what the STRS requirements are as far as them coming back to work.
Is that also applicable to PERS? Because I have public safety, so a lot of the folks I have are PERS retirees already. And some are in the STRS system.
Yeah, and I think PERS has,
980.
yeah, PERS has I think PERS has even more restrictions on, you can't even take public employment at some point. I mean, they've got some pretty stiff restrictions
Well, you
on
can't
it.
so long as you weren't in the position previously held.
Right.
But, my concern is if we had to do something like that, would we have to be concerned with the cap on number of hours other than the 67% rule?
You can hire them in at full-time, but the employee themselves might need to be concerned with their hours because that might, PERS or STRS might impact them personally. I don't think it would impact the district. This gives you the opportunity to hire somebody full-time in a substitute position, but it might have an impact on the individual. Does that make sense?
Yes, it does. Thank you.
Okay. All right. Some other considerations, if the temporary employee is considered hired for a complete year and then they are hired in a regular position in the following semester, then they're deemed to be a tenure track employee, and that first year of employment is considered to be a regular their first year, right? So a couple of things with this. All right, so if you have somebody leave and they're sick and they go out long term and you put in a full-time substitute, if the replacement person comes in, and this is where the education code gets fun, they serve a complete year, which is 75%, right? It's not 3/4 of a year, it's 75% of a year is considered a complete year. If they serve 75% of the year and then the person is still sick, or the person decides they're not coming back or whatever, then, and if you keep that same person comes back in a full-time position, then they've completed their first year of probationary and they're starting their second year of probationary service as a faculty member. Okay? Also, when you're using day-to-day substitutes, again, make sure the employee's contract that they're hired or their notice of assignment or the personnel action form or whatever you use specifically designates them as temporary, as a temporary substitute employee. It's very important that they be designated correctly at the time that they're brought in. All right, any questions on day-to-day substitutes? All right. Emergency temporary employees. So you can bring in temporary full-time employees for up to 20 days if it's to prevent a stoppage of business or an actual emergency. Okay, so this could be in the event of a union issue. If you've got a union strike and they're going to stop working, you can bring in employees for up to 20 days, or if there's an actual emergency, whatever that emergency might be, and you need to bring in full-time temporary employees, you can do that on an emergency basis for up to 20 days. And again, with the others, it's very important that you designate them as this is an emergency assignment, you're here for 20 days, and make sure you state the reason why. Did you have a question?
Yeah, just can you give me any examples of other emergencies? So like not having faculty for a class you have to offer in a program? Doesn't sound like it would be an emergency, but could it be?
Well, let's say there's an earthquake, or there's a terrorist attack, or and you decide that despite all that's going on, you still want to offer classes. The emergency, the stoppage of business part, I think, and the emergency, probably it can relate to a union. If there's a union strike and they refuse to come to work, and you want to continue offering classes even though your faculty members aren't going to show up for work.
So you have a nursing program with 4 semesters and you don't have a second semester instructor. It would stop the whole nursing program. Is that an emergency? It is to me, but
Yeah.
I don't know if
Yeah,
the
that-
state sees it as one.
Well, it prevents the stoppage of business or an actual emergency. So preventing the stoppage of business, if you don't have anybody in there, then that might. What I would strongly suggest is you have legal counsel put together an opinion for you and do the research if this issue has come up before, because that's it could be or it might not be. And maybe, what's an emergency? Is it something that the governor declares as an emergency, or is it something that the mayor declares? That's a good question.
But that's only for 20 days.
It's only for 20 days.
Oh, yeah, it doesn't help.
But
It
it
was 20
would.
working days, or it was 20 calendar days?
I would guess it's 20 working days, because, yeah, I would, usually when we're talking about the number of days, we're talking, especially with faculty, we're talking about work days. Okay, any questions about emergency employees? Any other questions?
I think what we have is that some of the terminology that we've used here
Yeah.
is different from the ed code and other language. So when we see temporary employees, it's different. It's like you have adjuncts, and then you might have an emergency where you need to hire an adjunct, or you might have an emergency where you need to hire a full-time temporary.
Right. And that,
Temporary is usually used, as I understand, for the full-time temporary faculty, and then others are adjuncts.
Yes.
there's a lot of places that will do that. They'll say, okay, these are adjuncts, and these are temporary, and these are sub. The reality is, they all fit under the umbrella of a temporary employee, right? And so it starts getting confusing when different districts start putting their own names on the types of employees. And the ed code says, well, we don't care what you call it, we're all temporary, these are the 67%ers. And I'm not even sure the ed code uses the term adjunct employee. I think that's a term that's come up in different schools, and they call them that. I've been to some districts where they're horribly offended by the term adjunct, and they would prefer to be called part-time, or they'd be preferred to call associate, or they'd be preferred to call something else, right? And so the term isn't as important as what the ed code says, and they're all temporary, 67%, day-to-day substitutes, emergencies. Okay. And that's a good point, though. Don't get confused by what they're called here. Any other questions on emergencies? Okay. Next type are for temporary classes. So these are, you can hire a temporary employee full-time to teach temporary classes. These are classes that don't exist after the first 3 school months, or there's other faculty responsibilities that don't last more than 3 school months, or it's a special day or evening class for adults or migratory populations of up to 4 months. And I didn't make this language up. This is in the ed code. As far as what they're talking about, I guess one of the classes I've seen are in the public safety. Sometimes they'll have 3-week or 4-week classes, and they're specialty classes of, with firefighters or police officers, and how to do hot stops, or how to do multi-level building fires and things like that. But those are done in modules, or they're done in smaller groups. Or if it's faculty responsibilities that don't last for more than 3 months, or if it's a special day or evening classes, migratory populations, I could guess at what that is, but I'm not exactly sure what's meant by that, yes.
It feels really strange to me, and you're in K-12, and so we teach classes that are fewer than 18 weeks all the time, and we have a conversion that we do that regularizes that for the state for an 18-week term. So those modular courses that maybe are 0.5 units, those really are outside.
Well, if they're less than 3 months, or they end before the first 3 months, then you can hire temporary employees for those. Now, you want to check your contract too to make sure that you haven't given away anything on with regard to hiring that. But these are the K-12 statutes are in the 40,000.
I know. It just feels like.
Well, and of course the history of that, you're probably right on that. But the history of it, they used to be all together. They used to be all in the same. The K-12 and the community college used to be all together, and they divided them. And some of the language stayed exactly the same, and some of the language was changed. And I mean, this may be something that comes up or doesn't come up.
I just kind of want to say to the deans in the room, so we will not be doing something like this for modular classes unless we determine collectively that that's something we do.
But we would hire an adjunct,
Yes,
and that would be what we
yes,
I don't see it.
which we do, yeah. So we just won't be tip of fund, this is some kind of extra special thing. Okay.
On these, so if the classes or duties extend beyond the 3 or 4 months, of course, the employee then becomes a tenure track employee. And with all of these, and I keep repeating it because this is one of the common mistakes we see, is they hired somebody in, but they didn't, on their hiring intake form, they didn't specifically identify them as being for a short-term class or for a substitute, or for, that's a very common mistake. So you want to make sure that whatever, if you're going to do that collectively, after you've all decided to do it and maybe gotten a legal opinion that says we can do this for that, it doesn't have to be from me, it can be from whoever you trust. You want to make sure that then it also has that the classification, that they're temporary. You want to put the length of their assignment and the reason for their assignment. Make it very, very clear why they're being brought in, for how long they're being brought in.
So that's probably something we want to go through with HR, how we're actually managing those contractual pieces.
And we're required to notify them before the first day of duty, is that right?
Yeah.
On the adjuncts? And the consequences of not?
Consequences of not, or you want them. If you don't designate them correctly, or if they exceed the minimum numbers, then they become a contract faculty member. They become a full-time probationary.
So I suspect that's something that we can take up. Yes.
Okay. You can have full-time temporary employees. Now this is a different vehicle.
Common.
This is more common. So this is you can hire a temporary employee to teach it for a complete school year or a complete semester. But there only can be a couple of reasons for that. One is, so we talked about the day-to-day substitutes. Somebody's absent, they come in and teach. This is when somebody's leave or they have a long-term illness, and it's limited to the number of full-time faculty that have a leave or a long-term illness. Okay, so if you've got somebody who goes out, you can have one person come in and fill that position on a full-time basis, but you can't have 2 people coming in to fill that and say, oh, well, we've got this person was teaching in 2 different areas, and so we're going to bring in 2 full-time people to replace that one. It's got to be a 1-to-1 ratio on filling in for that person. If the employee is then re-employed in a vacant position, so if somebody's on a long-term illness and they pass or they decide they're not going to continue teaching, that creates a vacant position. If that substitute or if that person, long-term substitute, is brought in, then they're deemed to be a tenure track the next year. And then their first year of service is deemed to be, their first year is considered their first year of their tenure track, and then they're starting their second. It doesn't include a position where the employee is on leave. In other words, if the employee can, if you've got one person who's sick for a semester, and then they come back, the person who was a substitute, and then you've got somebody else who goes out, that person can then, they can fill a substitute for one employee one semester, fill in as a substitute for the other semester, and then that doesn't trigger them coming back. It has to be in that same position. So a vacant position, it has to be the same position that they fill for the full year and then come back in a vacant position. It doesn't count if it's a different employee that they're substituting for. So if you've got somebody who's a good full-time sub and you'd like to use them, you can use them as long as they're not, a semester here and then a semester for somebody else, and you can document it. And again, when you're filling out the papers and you're initially hiring them as a substitute, make sure it's clear who they're substituting for and that the person's out on leave.
And if the person were to go out on leave in October, and we hire a full-time temp substitute to complete that term, that person's a day-to-day substitute until, and I can hire a day-to-day substitute to fill a full-time load at less than 100% of the term.
For 75%.
Okay.
75%.
All right.
Again, notice, make sure that expressly classifies the employee as temporary, state the reason for the assignment. The reason is so-and-so was absent. That's the person they're coming in and placing.
So in a situation where we have had searches that we've been unable to find an individual to fill the position or for whatever reason, and we need to hire an individual who's a full-time temporary sub, I guess. You consider the position vacant? It's not vacant because of leave or illness.
So a substitute position means that there is an existing employee who is just not at the district at the time, but it's expected that they'll come back. But if you've got somebody who leaves, right, who's departed, that's a vacancy, but that's not a substitute. When you're putting somebody in that position, that doesn't count as a substitute.
It counts as what?
It counts, well, if it's before September 1st, then you need to either fill those duties with adjuncts, or
In September 1, they would be,
you hire them as a contract. Before September, after September 1, they would be adjuncts. Before September 1, they need to be hired as a contract, right? If the vacancy occurs before September 1,
we hire them as an adjunct until the end of August.
I'm not sure you could hire them as an adjunct and then hire them temporary after that. I think if the vacancy occurs before September 1, you either fill the duties for the full year with adjuncts, or the person you're hiring to fill the full-time is going to be a contract employee. If it's after September 1,
It's just different from some practices,
okay,
because classes in community colleges typically start in August, and we find out maybe about this time that we need to find an individual to fill several unfilled positions.
right.
So they come on as a temporary full-time faculty member, and they start first day of class with that classification, and it may go to the end of December, the end of the semester, or maybe until May or June. So are you saying that we should call them something else?
Well, so you
We
can,
are not to do that anymore?
yeah, I wouldn't, we'd have to look at the specific situation, but I would, because they've got that September 1st timeline, and I would say that you run a risk of doing, if you hire somebody in, we get asked all the time, how do we hire somebody? Because you can hire classified employees, and you can just call them temporary, and you can use them for a period of time, and then you're done with it. There's not that same freedom with faculty because of they've set this up, and the reason is because there's less entitlement and less privilege that goes along with being temporary. The courts have held that they look at the statutes very strictly, and you have to fit very strictly within them. Now, I'm not saying that everybody does it that way, and districts do it however they want to sometimes. But there's a correct way to do it, and there's ways to do it.
So when you say that the person should be hired in as a contract employee, the problem is we couldn't hire a contract employee, which is why we need to find a temporary employee. So it's saying that.
But they're working full-time though, right?
Yes.
Yeah, and so I think that's where the problem comes. I mean, that's where the dilemma for the district comes in, is because you're trying to hire somebody and having difficulty hiring somebody, but you don't have enough adjuncts to fill that load either.
So in that situation, we should call the individual an adjunct. And
But they have to be,
load
and 67% and load balancing as well. And let them know that you're load balancing. We're going to drop you down the next semester.
And they could still continue participating in departmental activities as if they were a regular member, but we would just pay them at that rate and not count it towards their 67%.
So long as the department activities don't count towards SIUs, that would be fine. Yeah.
So when I used to understand the 67% rule a little differently, when I understood that to be the 2 out of 3 semesters, whatever, there was an exception for nursing because of the understanding that the legislation had about, finding nursing faculty,
Yes.
which is, pervasive problem. So does nursing have any exceptions here?
It's funny you mention that, because when we were putting this presentation together, I'm looking through it and I'm like, there's no nursing. Where's the nursing? There's an exception for nursing. The nursing exception expired at the end of 2015, and they haven't renewed that. So there used to be a nursing exception. And then the statute said that this expires on, I think it was July 30th of 2015, maybe it was December 30th. But the nursing exception that used to exist doesn't exist in the statute anymore.
So I have read a legal opinion at one time, I have to go find it again, that said that they thought that that was an oversight and that it was a mistake that they didn't include it in the new regulations. Are you aware of that interpretation of the elimination of the nursing exception?
I haven't, but I am aware of, so the way courts interpret statutes is they presume the legislature is aware of everything in the statute. And if there's an oversight, then they should fix it. And
Yeah.
if they don't
And
fix it,
I
then they
understand
must
that.
not have meant to.
Okay.
So, but as it currently stands today, and I don't know if there's pending legislation to fix that, but as it currently stands today, because I recalled that as well when I'm going through and I'm like, there's nothing in here about nursing. And so I specifically asked, and the person helping me came back and said, yeah, there used to be, but it expired just not long ago. Okay. A separate reason for hiring full-time faculty, we mentioned this before, is if you've got a higher enrollment of students in the semester as compared to the prior semesters in a particular area, then you can hire somebody in to come in and teach a complete year or a complete semester. But you've got to demonstrate that you had an increase in chemistry, so you hired a chemistry instructor, you had an increase in English enrollment, and it's not because somebody left, it's because you had an increase in the number of students that requires you to come in, and so you can hire them on a temporary basis for either the year or for the complete semester.
So in this case, they could start in August and be fine.
Yes.
So in the case of this, we have a position that was not able to be filled. If we can demonstrate there is higher enrollment, we could hire them as a full-time temp rather than an adjunct.
Yes, if you've got more students this year than last year, the number of faculty you hire needs to be relative to the number of the increase in students. So if you have 3 or 4 students, maybe not. If you have 20 or 30 students, you've probably got a pretty good justification for hiring additional folks on a temporary basis.
So that was my question about threshold, so you just kind of threw out some random numbers. So that threshold
Well,
would be a district determined need based on
I-
fulfilling their mission.
it's the answer is very simple. It's a reasonable basis,
Yeah.
right? So what's reasonable,
Yeah.
right? So what's reasonable
Say no
is.
more. I have a good sense of reasonableness.
Here's the way I define reasonableness. The district gets to decide what reasonable is in the very beginning. The district decides this is reasonable or not.
Yeah.
At some point, the district may have to justify that reasonableness in front of somebody who comes from Sacramento as an ALJ, and here's the other side arguing it. And so the more reasonable your position is, the stronger it is, the more reasonable it will be to the third party who comes in to decide it. You get to decide initially what reasonable is, but somebody else may decide ultimately what reasonable is.
That's a good threshold.
Okay?
So if your enrollments for the college are higher, in other words, you have to hire a temporary into the area where the increased enrollments are? Or can you, well, we have higher enrollment, so we can hire this many more as temporary, and we can put them where we want?
Well, there should be, you should see an impact. If you have more enrollment, there ought to be areas that are impacted. You would think there's areas that are impacted more than others. You want to try to tie it as close as you can to where those areas of impact are, because here's what would happen, right? Because I always look and see, okay, what happens when the fight comes, right? And they decide that you shouldn't have hired, or you didn't hire them correctly because there wasn't an increase, and so they want to be a contract employee. Okay, so if you've got an increase in chemistry students, but you hire an English instructor, and they'll look at the number of students that are taking English classes, and those English classes are staying the same for several years, but you hired an extra English instructor, you're going to have a pretty hard time to say, well, we have more students. Well, yes, they're all taking chemistry classes, right? So you need to show that wherever, and with the minimum qualifications and the disciplines, you're hiring faculty in for specific reasons. And so the faculty, if you're going to use this one, it needs to be in the areas where you've got the higher enrollment. All right. Other considerations. Okay, so for the higher enrollment, this is where you're limited to 2 semesters of full-time employment every 3 years. And this is where it gets confusing, because then they want to take this 2 semesters in 3 years and apply it to other forms. It only applies for the higher enrollment. And again, make sure the contract and the hiring documents specifically say why they were being brought in. Categorically, any questions about higher enrollment before we move on? Okay. Categorically funded employees. You can bring in temporary employees to perform services on a temporary basis for categorically funded projects. And there doesn't need to be a set limit on how long you bring those in. They can be 1 year, 3 years, 5 years. There's no time limit on that. And the employee can be terminated at the end of the project or at the end of the funding for which they were hired. So if the project ends, it's a set term, it's only for a year, or if you've got an ongoing project and all of a sudden they notify you that, you know what, funding stopped on this, we're not going to offer this funding anymore, then you can let them go. There's no specific notice that's needed to be required. There's no 90-day notice, there's no March 15th notice, there's no 6-month notice on these categorical positions. Okay, there's some confusion sometimes where you've got a full-time faculty member who then does work on a categorically funded program. They keep their full-time status. That doesn't affect them. This is only when you hire somebody brand new to the district and you bring them in under a categorically funded program and they stay under a categorically funded program. If you bring somebody in under a categorically funded program and you start giving them non-general funded classes or assignments, then you start running the risk that they can be that this categorical exception doesn't apply, because now they're not strictly under categorically funded programs, they're doing regular assignments as well. And so that can cause that employee to fall outside of this exception.
Okay, so here,
What's that?
could we slow down on this one?
Yes.
Did somebody else have a question?
You can go for
In
it.
this case, what do you call that person? Because if you hire him, for example, a counselor who's working on a categorically funded project, they have the same duties as other counseling faculty. So as far as duties, they're the same, and then you would have to evaluate them somehow,
Absolutely.
but they don't get tenure.
Right.
So they're supposed to do the duties like a counselor, regular counselor, but in this specific program.
But that's because, so they've set this up so that if it's a state or local or federally funded program and they're giving you the money for these employees, that you can then hire additional employees to do those duties. Even if it could be teaching, it can be counseling, it can be any of the same duties as before, but the funding source is coming from a state or federal source. They recognize that if we're providing the source and then that source goes away, or if it's a short-term project and that project goes away, the district shouldn't be burdened then with having to deal with this employee that's an additional cost. So as long as, but what I have for clients is a categorical funded employee contract. It spells out specifically how they're employed. It's on a categorical position. They understand that if the funding goes away or the project ends, they lose their job at that point.
And that's the same for classified staff.
No, classified staff are different. There's a section in Ed Code that says it doesn't matter what the source of funding is.
They get not tenure rights, but seniority.
They get seniority rights.
Involved, regardless of funding.
That's right.
And when categorical goes away, you still own them.
You still own them, but the difference is with classified, you've always got a 60-day layoff period. So anytime during the year, you can lay them off with a 60-day notice. With faculty, you can only lay them off once a year, and it's effective at the end of the year. So because there's that revolving ability to lower your costs if your categorical funding ends for your classified, it doesn't matter what the funding source is. But with faculty, they've made it different so that they're temporary and they're based on the project. Okay?
So Amanda had a quick question too.
Yeah.
Okay, so I do have a question about so these employees, and it's threshold related. So for example, CalWorks funding coming from the state, right, at a certain amount. And so we're looking to hire a CalWorks counselor.
Okay.
At what point do we say, I'm understanding the way that I read this, that we don't get to terminate them unless the project or the funding goes away. right?
Right,
So unless we have costs.
right.
Right.
We'll
So
get to that.
without cost, we can't terminate them unless the funding of the project goes away. Does the funding have to be like for the year less than their cost? Or is there a point at which their cost coupled with, the fact that the project is also meant to provide direct aid to students? Where is the funding gone? If they cut the funding down to a point where we can afford the counselor but not the project as it relates to the students, is that acceptable? Or does the funding have to be cut all the way to where we can't even afford their salary and benefits?
I don't think the funding needs to be completely cut, but I think it needs to be relative to what reductions you make,
Okay,
right? I think that's the answer on it.
all right.
Okay.
But if we can release them at the end of any day or end of any week, but on categorical, it has to be at the end of the project or funding, or can we still release them at the end of any day or week?
Great that you asked that question.
Turn the page, thank you.
The only time that an employee hired under categorically funded projects can be terminated is at the expiration of the project or at the end of the funding. If you hire an employee for more or less than the remaining term of the project, or you terminate the employee before or after the end of the project, then you have to treat them like they're a contract employee. You have to treat them like a probationary employee. So and there was a case that just came out on this in the last couple of years where, and it used to be, this is a change, because it used to be, and I used to give opinions that said, you're categorically funded, you're temporary, we're gonna let you go, sorry, it's not working out, thanks, appreciate it, see you, right? There was a case that came out, and then the court went through and said, yeah, it only says at the end of the project or at the end of the funding, so if you're gonna terminate them for cause before then, you have to terminate them as if they were a probationary, they're treated the same as if they were a contract employee, okay? So, yeah.
Which means I can still do a March 15th
You
notice.
do March 15th notice, right? And then they've got the right to a hearing and go through that whole process. And if they've been there, and I think this case even went so far as to say, if they've been here 4 years and you try to term them before the end of the project or the end of the funding, you might have to go through the full-time faculty termination process as opposed to the probationary faculty process.
What
Right?
district was that?
What, the district, I
Remember
don't,
what-
I don't remember the district, but I can
I'm just curious.
get the case. Let's see if I have the case here. I don't have the case, but I can get that to you. But that just came out like in the last year or so. It's fairly recent. Other considerations. The employee has to have a contract or a written notice of assignment that expressly indicates that they're temporary employees under a categorically funded program. And you want to identify the program. This is a constant theme in this. This is where this one comes up quite a bit. And then if they're employed in a complete year and they're re-employed in a regular position, so if they've served in a categorical funded position and then you decide that the funding ends or the project ends and you want to bring them back into another position the next year, they don't start as a first year. They get to count those years prior as towards their achieving tenure. Okay?
And that would be the same if I had brought in a long-term substitute. That person would get credit for the first year.
If you bring in a long-term substitute and then you hire them in the next year, yes, that's right.
Even though they may not have been evaluated as a contract faculty.
That's
That's
right.
actually why you probably want to evaluate anybody in that role.
That's right.
As though they were.
And especially the full-time. If you've got somebody in a full-time position, you may want to evaluate them. Because you may find things that you don't want them back, or there's reasons you need to. All right, so kind of an overview. Common misperceptions with full-time temporary, that you can use full-time temporary employees in place of retired employees for a year. So again, if somebody leaves the district, they're not absent because of illness, but they leave the district, you got to either hire them or you got to bring in adjuncts. And only after the September date if no other employees are available. Adjunct employees can't be hired as, one of the exceptions is adjunct. You can't hire an adjunct to serve as your full-time substitute. You can, they're separate. You can be an adjunct one semester, then you specifically hire them in as a full-time substitute or a full-time temporary the second semester. It doesn't mess up the 67% rule if you've properly classified them in the hiring documents as a full-time substitute or a full-time temporary. And categorical employees can be summarily dismissed during the term of the grant. That used to be the case, that used to be the opinion we gave out, but that recent case changed that. The consequences of these, the courts have held that because temporary employees don't get the same protections as full-time employees, the authority on this has to be strict. You have to follow these statutes to the letter. So when a temporary employee is not properly classified as temporary, then the default is they must have been intended to be a probationary employee, right? You've got probationary and full-time, and then the exceptions are the temporary. And if you don't meet the exceptions, including the initial classification, then the default goes to a contract employee or a probationary employee. The community college instructor whose workload exceeds 67% of a full-time assignment can't be temporary, and therefore they have to be a contract. There was a case prior to this Peralta case which said, well, the statute doesn't say they automatically become permanent, so we're not going to do that. Then this Peralta case came out and said, no, that's nonsense. In order to qualify as for 60% of the time, in order to qualify as temporary, you have to be under 60%, and if you're not under 60%, the only default is that you're a contract employee. Employees who are not properly classified as full-time temporaries are also entitled to reclassification as contract
And then,
employees.
can I ask one quick question?
So let's say we did err on that first bullet, and someone did come to us who had been working 72%, and we realized we actually owned that person.
Over
We own
the
that
years?
person, yeah, and we're in semester 4, and
Yeah,
it's
okay.
a crash and burn.
Yeah,
We only owe that person at 72%.
well, that's a good question. That's the argument I would make, right? Because-
I've been in a district where we made that argument.
Yeah, and that's the argument I was making, you only achieve that level, and I've seen that argument made before. It's going to depend on who you get as your judge, whether they buy that or not, or they'll say, wait a minute, you're above, you're entitled to a full-time load. Right? If you're a full-time faculty, if you're a contract faculty member, you're a full-time load. You're entitled to a full-time load. Now, you've got the retirement where you can reduce load, where you can drop down. But ordinarily, if you're a full-time faculty member, contract or probationary, you're entitled to a load. But I've seen that argument made before. But it just going to kind of depend on, I haven't seen cases on it, but I've seen the argument made.
And that's over 2 semesters?
Well, yeah, so that's over 2 semesters here now. Thank you last year.
But the law still, even though the law changed, it still applies?
This was the collective bargaining agreement that changed. Yeah.
In 79, though.
Even though the law changed, I'm sorry, your question?
Some things have changed since then, but this still holds.
Yes, that's the whole, the number, it used to be 60%, now it's
Right.
67%, but yeah. And so the default is if you exceed that if you exceed 67% of whatever is determined to be a full-time faculty member's load, then the default is you become a contract employee. Okay? Every best practices, every employee should have a contract or another assignment for every semester that classifies them as temporary. It says the type of their temporary assignment, the length of their assignment, the reason for their assignment. Consultant human resources, if you have employees working in multiple departments, we talked about this at the beginning, where if you've got somebody who's qualified in different areas, you don't want them to exceed the 67% because one department is not keeping track of what the other department's doing and they get a higher load than that. When you've got adjunct employees assigned as a full-time or day-to-day substitutes, just make sure that it's properly documented and designated. And if there's any questions about whether something qualifies or counts towards your SIUs, make sure you're talking to HR or instruction or whoever you need to talk to. Make sure that you're clear on what their assignments are. And that's it for that. Any questions? Yes.
I had a question about, you were talking about classified staff, and you were saying about a 60-day layoff.
There's a 60-day layoff process for classified staff.
Can you tell me about that?
Yeah. In order to lay off a classified employee, you have to give them at least 60 days notice. And it can be any time. So it can be in February.
Grounds for layoff.
It has to be lack of work and lack of funds. Lack of work, lack of
Oh, I
funds.
see, yeah.
Either one of those. But it can happen, there's with faculty layoffs, you have to give the notice by March 15th, and it's effective at the end of the year. Right? And they've got a right to a hearing, and you to come in and determine the grant. With classified layoffs, there's no hearing, and it's revolving. It's just the only restriction is you give them 60 days, and there's a lack of work or lack of funds. Okay? And lack of funds is the district's decision on where it wants to allocate resources. If the district says, you know what, we don't have funds to do this anymore, that's sufficient. Okay? All right, anybody else have any questions? Okay, thank you.